Realize.
All right. Morning, this is April 3rd, 2024, and we're taking up H563, an act relating to criminal motor vehicle offenses involving unlawful trespass, theft, or unauthorized operation. And it's our first witness is Sean Burke. Chief Sean Burke is the chief of the South Burlington Police Department. Gave you that other city in Chittenden County. Are you still in town?
We're city.
You're still.
We're city. And I was formerly employed by the city of Burlington for 21 years. So
Well,
it's easy to confuse. Or you, Senator Booth?
good. So, Chief, we've been looking at this bill, and I can remember writing the statutes that we currently have in place. And some of us were surprised by the need for the no trespass
On the car.
change. Huh?
On the car.
On the car. But not yet convinced that we need to change the motor vehicle statutes on operating without the owner's consent, the two-stage piece that's in current law, which hopefully provides when it's a joyride, and secondly, when it's actual theft, trying to steal the vehicle. So maybe you can enlighten us from a law enforcement point of view.
I appreciate that very much. And I've got a short prepared piece of testimony that I shared with the clerk last night late. I'm sorry. If hopefully that'll get socialized. But good morning, Senators. I appreciate the opportunity to testify on H563. My name is Sean Burke, and I do have the privilege of serving as the Chief of Police in the city of South Burlington. Chittenden County has been experiencing a sharp increase in both the number of reported thefts from motor vehicles and stolen cars. This property crime trend has resulted in large segments of the community experiencing harm. This harm has eroded how constituents view public safety in their neighborhoods. The data points in South Burlington illustrate the severity of the increase seen countywide. And as you're being provided this document right now, what the top illustration is the number of reported stolen cars to the South Burlington Police Department. And you'll see 2018, 2019 fairly static around 25, and then a gradual increase into 21, and then a dramatic increase to years 22 and 23, where we have received 122 and 126 reported stolen cars. A similar pattern exists also with larceny from motor vehicles or theft from cars. In 2018, 87, hovering around 120 through 19 to 22. In calendar year 23, 350 reported larceny from motor vehicles. Many of the people responsible for these crimes are justice involved, substance dependent, impoverished, and are not in a place to address the challenges fueling their criminality. Another challenge is the lack of adequate statutory framework to address these crimes in general. H563 improves the relevant statutory framework Vermont law enforcement relies upon when investigating these crimes. The proposed language in Title 13, 2501 provides clear statutory guidance for attempts made to steal a motor vehicle. Law enforcement does encounter persons in the act at times. The addition of this language makes clear which statute is applicable, grand larceny as opposed to operating without owner's consent. The proposed language to Title 13, 3705, the relevant trespass statute, closes a loophole suspects use when law enforcement encounters them in the act of looking in cars for items to steal. Despite how reasonable it is to assume that a person prowling through parked cars in a neighborhood is committing a crime, that is often not the case. Many of these suspects are released on scene absent finding the suspect with stolen property on their person or making an admission against their own penal interest. The proposed change in the bill provides greater clarity. The most critical piece of the proposed language is the addition of a new or should have known standard. Constituents are simply baffled to learn that a person they don't know can enter or operate their car without their consent and not be held accountable. The existing statutory language of Title 23, 1094, the operating without owner's consent statute, was thoughtfully constructed to differentiate between the act of a joyride and depriving a person of their car. The current knowingly standard is being exploited by those involved in vehicle theft. simply telling officers that they were lent or given the stolen car by someone who is not the registered owner. Without being able to link the apprehended person with the theft of the car, the knowingly standard is difficult to prove and nearly impossible to explain to the crime victim. A majority of the cars stolen are recovered. They have been used in other crimes, left soiled with drug paraphernalia and filled with stolen property, and sometimes extensively damaged. The harm that the car owners experience is wide-ranging. Fear of fentanyl exposure, fear of exposure to bloodborne pathogens, and the financial burden of restoring their car following recovery. This is often overwhelming for many and cost prohibitive for some. A more effective criminal justice intervention is needed to both hold the offenders accountable and restore crime victims in a meaningful way. H563 is an improvement in this regard, and I'm happy to answer any questions.
Okay. And, let's start with the knowingly. How does that affect? So what you're saying is that thief will say, well, Mr. Jones said I could use the car.
That's correct, and usually that Mr. Jones is not even the registered owner. And I think what's also kind of important table setting around this conversation is the fact that this crime trend isn't about the car. So this isn't like there's a chop ring gone in 60 seconds like portrayed in the movies, but rather these are unlocked cars with the keys left in them, unfortunately. These justice involved individuals will steal these cars to use in any number of other crimes, be that a burglary spree or a retail theft spree, general transportation to obtain drugs or facilitate other criminal activities. And then once the car runs out of gas or gets a little too hot on the law enforcement radar, they'll dump it. Or in the interim, they will have Confederates, folks that they're working with or associated with through criminal enterprise, where they'll say, you can just go ahead, you can have this car. And officers, when they generally will encounter that second or third party that's in possession of the car, have a very difficult time proving the knowingly standard, despite the fact that the person in possession of the car has no connection with the registered owner, will oftentimes not even know who the registered owner is, and really no valid explanation as to how they, how in their perception, how did they come into just being given this piece of property that's worth now $15,000 to $45,000 in any given circumstance.
Yeah, I was down getting my car repaired last Monday, and I just walking around the showroom, I couldn't believe the price of a car, $55,000. I said to the salesman, who I know fairly well, I said, well, that's a hell of a lot more than I paid for my house. But the value of vehicles now is such, even trucks, $75,000 for a truck. Just for it, Question for Michelle to take note of is the knowingly standard. I didn't hear much about that when we went through it last week.
So I do have a question about the or should have known, and I'm not sure if that's in the example.
Michelle's not here because Rebecca Ramos' father passed away and she tried to help her make arrangements and things like that.
Got it. So you have a person who steals the car. They pass it on to a second person. That person then gets caught. They represent that it was represented to me as a gift. Would that trigger the should have known standard?
Yes, and the way that I try to frame it in my mind is it reasonable to believe that this person actually thought that becoming in possession of this car is at all lawful? And the scenarios that are presented in the field to our investigating officers, it just simply isn't reasonable. And that's really highlighted when we try to break that down for the person who has lost their car and the reverb, because they're just exasperated that this person, oftentimes, struggling with a lot of different issues, but involved in a lot of different criminality, is in possession of the car that they reported stolen, but yet the state doesn't feel that we have not met the evidentiary standard to prosecute them.
Mm-hmm.
Okay. So, I have a note here on page 3, lines 10 through 16, that's where the language knows or should know comes in. And then secondly is, that section tries to address someone just trying to steal the contents of the car. And then back on page 4, line 17, the person should have known, the person did not have consent.
Yeah.
Those are the two areas you're talking about.
Yes, Senator.
How common is it for people to just break into cars and just for the contents, not to steal?
So as the crime trend illustrates in the graph in South Burlington, it's become a really pressing issue. And it's perennial. You know, it's been something that I've encountered over my 30 years in the business that, you know, weather gets a little bit better and thieves will go out and rummage through neighborhoods looking for unlocked cars with any number of valuables left in those. That is really, really prevalent now, especially in more the urban settings where we have like common parking garages under multi-unit buildings, just a target-rich environment. And again, it's something that we plead with the public to help us and be part of the public safety solution by locking their cars and taking their valuables. But it's also one of those points that we reflect upon when we're called to a scenario, and oftentimes we will be able to encounter the suspects, maybe even nearby, but they have yet to steal something, but maybe we've got some video of them in a car, in a public parking lot, and that kind of thing, and there's no way for us to refer them or even, you know, a referral to that's crime related to our community justice center because they technically haven't done anything wrong as the unlawful trespass statute is constructed.
Mm-hmm. A couple of us related stories, me, myself included, of getting into somebody's car by mistake. I actually got a haircut, walked across the street, jumped into the car, put my key in the ignition and it wouldn't work. And I said, oh God, I took my wife's car, my wife's keys. Not thinking that, you know. And then tried to grab mine and it still didn't fit. And I'm in there and looking around, what the hell do I do now? And all of a sudden I realized this isn't my car. So I sneak out of the car and go back down the street a few feet, and there's my car, and get in the car and drive off. I just want to make sure that I wouldn't be subject to an arrest and prosecution by whatever language we put in, and some other folks related similar.
Oh, I've done it more than once. I have a Nissan Sentra,
Yeah.
dark blue, which has to be the most common car out there. So I'll pull in, sometimes there will be 3 blue neon Sentras. So I've been saved by other people locking their doors, but that's about it.
Well, I locked my door, so I, unlocked that door with my key, and of course it unlocked because it was not locked. So I just opened the car door.
Yeah, I appreciate both those reflections, and that's where I think law enforcement has to show, some reason. I haven't encountered exactly that, but what I have encountered that's very similar is you'll be called to a multi-unit residential, whether it's a townhome situation or an apartment house, and the report will be someone's trying to get in my front door, and we've responded and found the neighbor from next door trying to put their key in the lock because the units are identical. And, sometimes after a night on the town, sometimes it's just because we're tired after work. And it's really easy to discern. There's no nefarious activity going on here. What we're confronted with is we'll find people that we know steal from cars or that are involved in stealing the cars themselves. We'll be called to a neighborhood. We'll encounter them, but they've yet to really execute or fulfill their mission for the night. and we simply have to let them go, despite having, some evidence of them physically being in people's cars, prowling around open car decks, parking lots, and that kind of thing. There's very little that we can do about that. And, despite it's a little frustrating for the police, I get that, that's fine. It's a frustrating job. It's really frustrating for our constituents.
I'm just wondering, and this might be a question for Michelle, but on page 4, it says the person takes, obtains, operates, uses, or continues to operate. And I don't know what the purpose for continues to operate is, because you've already triggered the offense. So continues to operate seems like it doesn't add anything. You could get rid of it. In your mind, is there a need for that?
Not in my mind, but I would definitely refer to counsel.
Okay.
In response to that, I think part of it is if you've taken the car and you get a call from the owner saying, hey, you took my car, I didn't give you permission, and the person who's driving it says, too bad, I'm gonna keep driving your car. I think that situation is what continues to operate would cover.
I see, but they're already using the car. So they've already run afoul of the law. So it doesn't mean they get charged twice. It doesn't make the case any stronger. So I guess I see the situation, but they're already guilty under this without continuing to
I
operate.
think, as I recall.
Yeah.
This is years ago that we wrote this language. I believe that was distinguished between the joyride and the actual, operating without the owner's consent and trying to steal the car. We were trying to differentiate. So continues to drive the vehicle. The joyride is, we're taking it around the block. We're gonna go show our girlfriends that are Corvette we just grabbed. That type of behavior, and then we're gonna either return it or, whatever. The other is trying to deprive the owner of the vehicle and continues to operate. I think that's what we were doing. This continues as current law.
Yeah, and maybe it seems to me that if they're operating it, that's the crime. And then continuing to operate it doesn't add more.
But one of them's a 6-month misdemeanor, and the other's 2 or 3 year felony. I can't remember which.
Probably Michelle's question.
So I wonder, and I don't know, but I can imagine a situation where someone does give permission for their car to be used and then says, bring it back. And the person says, no, thanks. And that could maybe be this space. I don't know. But that's the sort of first thing that pops.
That would make more sense, because then they had permission up to a point and then operating it, and then they continue after being told no. So, yeah.
Well, that was one example that we had back in the day was the woman who gave permission to her boyfriend to use the car, and then he took it to North Adams and had it crushed.
We hear about so many happy relationships in this committee.
Yeah, and he only got about $25 for the car.
But there was the satisfaction.
But yeah, he did take care of the vehicle. That's a true story from Bennington.
Oh, I do have
Only in Bennington would they take it to out of state and have it crushed.
I do have one
Show
other.
her.
Oh, sorry. Okay.
Yeah.
So at the bottom of your testimony on the first page, you say many of the people responsible for these crimes are justice involved, substance dependent, impoverished, and are not in a place to address the challenges fueling their criminality. I think that's a very apropos way of looking at what's going on, but the H563 is entirely on the criminal side. Should we be adding something because what that says in essence is they're unable to do anything else, right? If they're not in a place to address the challenges fueling their criminality.
So I think unable and unwilling are two different things. And when we see folks that are kind of wrapped into either substance use disorder or some other situation, you know, they as individuals need to identify when they're willing to enter treatment. But parallel to that, we need to have a criminal justice response for when people aren't doing this and are harming, you know, the greater community. So.
And in other words, I'm complimenting the fact that you're not just asking for penalties, you're acknowledging that they're in a place where, so I'm just wondering, should we be exploring a more holistic approach to the problem where we add to this something around services or something around, so we've been talking in here about pretrial services and that sort of thing.
Yeah, and I think there's probably a lot to, you know, given everything that we've experienced in Vermont since the opioid crisis broke out a long time ago, there's probably a lot of things that we would rather re-engineer because it's been a new experience. And I think that's a huge undertaking and one that's worthwhile doing. But in the short term, I do feel that we need to strengthen some of our, you know, criminal statutes in order to have a degree of accountability. Because this is, you know, even in Chittenden County, we're talking about a fairly manageable number of recidivists that are really driving this crime trend.
Yeah.
So one of the things you had said is that people can't even go through the restorative justice process, but it is not my understanding that someone has to be charged with a crime in order to go through that process. We have a whole, particularly in Chittenden County, pre-charge avenue for that. So I guess I'm a little curious as to how our current statutes are preventing people from engaging in the restorative justice process.
So if we haven't met an actual probable cause standard for a crime, there's really there's no way to compel a person to engage. Now, we always, on the restorative justice side, we always want a willing participant on all, you know, in all three facets of who's represented at the table, the affected party, the responsible party, and the broader community. But absent actually having a crime to refer, there's really no motivation to engage in the restorative justice if you know, especially these folks that are justice involved, that there's no charge at the end of this tunnel. That there's no, if I don't engage with the Community Justice Center, nothing further is going to happen to me. So there's really no motivation.
So am I understanding right that if we made these changes and you found somebody who was rummaging around in a car or had taken the car and should have known they didn't have permission, those people could be diverted?
Yes.
Okay. So that, I guess that speaks to my question here in a way that's makes me like this better.
I mean, I think I would want to see, given that there's an acknowledgement that the vast majority of these people are struggling with substance use, are living in poverty, are facing so many of the social determinants of criminal legal involvement. If we are going to move in this direction, I'd want to see some sort of mandatory first offense to restorative justice, rather to try and alleviate the underlying issues rather than just immediate sort of larger criminal legal involvement, given that we know that that is unlikely to make someone better in those areas.
No, and I agree with that. You know, I will say though, until we kind of iron out what's going on with sealed and expunged records, that first offense, any number of offense can be a little fickle to figure out because sometimes records of these incidents are vanishing. So,
I mean, it takes 2 years for it to vanish, and I'd argue if someone's gone 2 years without re-engaging, that they might be a perfectly valid candidate to re-engage in the process of restorative justice.
sure.
Well, I'm not supportive of doing something automatically in statute that doesn't allow courts or prosecutors to make some kind of decision about individuals. I think that's a huge mistake, taking one crime and saying, we're gonna automatically, if somebody commits motor vehicle theft, it breaks into a motor vehicle to steal something, that we're automatically gonna put them in diversion or pre-charge. I mean, I think it should be the general trend.
I wonder if we could craft it in a way that sort of said, like, that is the assumption, unless the state's attorney feels that it should be otherwise and can put that on the record.
I misspoke, by the way, it's a 2-year felony, 2-year misdemeanor and a 5-year felony, I think.
I got a question, Senator Sears.
Yeah.
If you don't mind. I think that the chief's testimony was not the vast majority of the people are responsible for this, that many of the people are responsible for this. Okay, there's a big difference between vast and in my experience, in the few years that I was in law enforcement, I can assure you that I always thought the OOC laws need to be addressed. If it was your car, you'd have a different stance on this. I have seen several experiences, the stories I won't even get into, okay? But people need to be held accountable for their actions. We need to find an avenue to get them treatment, if in fact they need treatment, but that doesn't take away the value of this particular bill in hand. So my question to you, Chief, is, and I've read the papers, I pay attention to the media and so on and so forth. So out of these stolen vehicles and larcenies from motor vehicles, what percentage are being prosecuted in Chittenden County? Didn't mean to put you on the spot.
No. And I don't have the exact metrics, but I will say that it's a little more defendant specific than charge specific, meaning that if we get a case on someone that's got a full docket already, the state is more likely to file those charges. We do, by virtue of our organization, refer first-time misdemeanor offenses directly to our community justice center. So we're doing that already. They're addressing, about 150 cases upstairs a year. I don't have the breakdown of exactly how many larceny for motor vehicle as opposed to, retail theft and so on and so forth. But I would say that in Chittenden County, between some of the policy stance, attribute a lot to the backlog, that many of these property crime misdemeanors are not being filed, even when we offer a defendant an opportunity at restorative justice or the community justice center and they fail to engage, and we refer that case just by way of process to the prosecutor's office. Oftentimes they're not filed, and I know that Sarah has a position on why that is.
So just one quick follow-up. So in your opinion only, when it comes to the motor vehicle thefts, the theft of the actual motor vehicle, do you think that because of that stance, that could be a part of why this is contributing to such a large amount increase in motor vehicle thefts in Chittenden County?
Yeah, well, and certainly we have strict guidance from the prosecutor on the current statutory framework, and it makes filing the charge very difficult. And if we had what I will call the improved standard as proposed in the bill, we could meet that evidentiary standard. There could be accountability for the responsible party, but more importantly, there could be some type of actual resolution for the person that was harmed, the crime victim that lost their car and has to endure everything that goes into when these things are recovered, because they are in large number not in a state of affair where they can just be simply put back in the family garage and used the next day.
Thank you.
I do want to be cautious about attributing the rise in motor vehicle thefts in Chittenden County to one person's policies, given that we've seen a rise in motor vehicle thefts all across the country, regardless of whether or not they're conservative prosecutors or progressive prosecutors. So I do think it's important to note that it is not just, this is a nationwide issue right now.
And I'll just add to that, the perception of Chittenden County as a place that's weak or soft on crime is not new. That goes back to Pat Leahy, who was the first state's attorney to be diverting marijuana cases and not prosecuting them, and he took a lot of heat for that. So I think relative to the state, Chittenden County is always more progressive in its thinking and more tending more toward diversion and practices like that. So I hear what you're saying about the state's attorney there. I just think it's part of the broader perception sometimes of Chittenden County. Although Senator Norris is not entirely wrong, I think there's probably a connection. I don't know if it accounts for the full spike there.
I think Chittenden County too is our most populous, most densely populated county, and as we also see in crime trend data, more populated areas tend to have more crime, and so I think there's a lot of things here, and correlational data that should not be construed into causational data.
Well, as we look at this bill to mark up, I appreciate the comments from the chief and that keep them in mind. I'm still concerned about section 1, that attempting to steal a motor vehicle becomes a 5-year felony, which attempting to steal, and I don't know if somebody's actually, and then we try to, did they know what they were doing? Then we get into the knowing standard, and so somebody who broke in to just see what was in the glove compartment, are they attempting to steal the vehicle? Or are they just attempting to steal things out of the vehicle? And we make it a 5-year felony.
That seems
a fairly serious crime.
petty theft more than.
Well, that's the difference, but
Yeah.
how do we know what they do? And then we change the knowing standard. And I think you're gonna see a lot more people charged under attempting to steal who just broke in to steal contents, which I'm not suggesting is okay, but it's a very different crime.
I think with the attempt, you have to take a tangible step towards actually completing that crime. So, rummaging around through the glove box or the center console, that's, that would fall into the trespass part. But, trying to, if you found a spare key and you're trying to get the car to start, that's obviously an attempt, but there has to be that step forward that is part of, I'm just trying to say you have to take a tangible step when it comes to attempt of a crime.
Well, I'm
just being in the car isn't.
I'm looking at page 3, lines 10 through 16, it tries to deal with rummaging through the car. That's a 3-month felony, misdemeanor, and a $500 fine. How do I know which is that person gonna get charged with? And that's what you're talking.
Yeah, it all depends on the facts and the circumstances that, the officer finds through their investigation and statements, surveillance, video footage, things like that, so.
But I'm just expressing my concern that I just have a feeling that there'll be a lot of charges for attempting.
If I could offer one reflection in that regard, the legal standard that we would be searching for is the overt act for the actual theft of the motor vehicle. In my interpretation, just representing my role as the chief in South Burlington, I see the change to the grand larceny statute less important, because if we had a actionable case for grand larceny of a motor vehicle, we could likely still make that case as an attempt in current statutory framework.
Right.
And I don't know if the threat of a 5-year sentence is really going to have the deterrent effect that we're looking for, but rather I really see the utility in this bill being in the provisions related to the trespass issues and also the should have known standard for operating without owner's consent, because that is really where we're not meeting the public safety goals of our constituents.
So I think we've questioned the need for section 1. Senator Wells.
Well, Senator Shears, I agree with your concern about sort of raising that to a 5-year felony, and certainly we know that the Department of Justice data shows that the severity of the punishment has very little deterrent effect. It is more about getting caught and facing justice swiftly, and so I certainly would be in support of not creating a larger crime, but really thinking about making sure that we hold people accountable, and certainly restorative justice can be one way that we hold people accountable.
So, thank you, Chief.
Thank you.
Appreciate you being here.
Thank you. I think I'm up on another bill, so I'll be around.
Yeah, I was gonna ask you about retail theft.
up on that one, I
Yeah,
think, later
that's
this
what I
morning.
figured.
Yeah, you're on retail theft.
To be clear, he's not
Retail
doing
theft in South Carolina?
it.
All right, so our next.
And he might get caught.
witnesses are, Wyndham County, or excuse me, the Brattleboro Police Department Lieutenant Andrew Adam Petlock. Are you here by Zoom, sir? By any chance?
I am, sir.
Lieutenant, thank you for being here. I think you know Senator Sheen, but I'll let him introduce himself and then.
Good to see you.
I'm Senator Phil Baruth from Chittenden Central District.
Senator Bob Norris, Franklin County, in the town of Elbert and Grand Isle.
Senator Tanya Vihovsky, I also represent the Chittenden Central District.
I'm Dick Sears, Chair of the committee, as well as State Senator of the Bennington District, which includes Wilmington, or just across the mountain from it.
Well, thank you for allowing me to be here, senators, and I appreciate the invite. So, my name is Adam Petlock. I'm the day shift lieutenant here in Brattleboro. I've been with the department about 14 years, 7 of which in the capacity of a supervisor. I can say that I absolutely understand the balance and the need for accountability as well as treatment in offenders, as I do run all of our outreach programs here in Brattleboro, so I certainly have an understanding of all that. And I certainly would echo a lot of what the chief said, and a lot of what I'm going to say has already been addressed, but I'm going to read my prepared statement anyways.
Please do.
I have seen the transitions that have occurred as the result of the opiate crisis and the unprecedented increase in property crimes. And in that, Brattleboro has been hit especially hard. I believe that is a result of a number of factors, one of them being that the laws here in Vermont are viewed as less stringent than those in neighboring states such as Massachusetts and New Hampshire. These property crimes have created a great deal of stress for those in our community. People find an immense sense of privacy in their vehicles. And when that's violated, that has a huge effect on people. Officers from the BPD handled, I was speaking in approximate numbers, about 258 reported thefts from motor vehicles over the last year and a half. Often people in the community want to help. They send us videos of people actually entering their vehicles. Often we have to explain to them that we can't make an arrest because they didn't take anything or we can't prove what they did take. A prime example being loose change, which is often taken from cars, and very difficult for us to prove that that change was taken from that vehicle. This obviously creates a lot of frustration for people in town. Since the beginning of 2023, we've also received approximately 46 reports involving stolen vehicles. Many of these reports involve people who left their keys in the vehicle or left it running, but many are the result of people loaning their vehicles out to others who in turn loan it out to someone else, as we've discussed. There's numerous examples of where we've been unable to charge people in possession of these vehicles because we can't meet the burden of proving that the person knew the vehicle was stolen. I'll provide a brief example. We had a woman who let her son borrow her vehicle. The son, in what could only be viewed as a drug debt, allowed somebody else to use the vehicle. In the process of that person using the vehicle, we had a very difficult time proving that that person knew the vehicle was stolen, even though one could infer that that person should have known that the car was stolen and that they didn't have the right to use it and that they didn't have the consent of the owner of the car. I believe that the new language in the unlawful trespass statute would better equip us to respond, make arrests, get people into the court system, corrections, or treatment, however that comes about. The additional language in the OOC statute indicating that the person should have known the car was stolen and did not have the consent of the owner would better equip us to hold people responsible in that regard. I also want to speak, and this has been addressed as well earlier on, but I also want to speak to the fact that law enforcement officers are very equipped to use their discretion and discern between criminals that are trying to steal people's vehicles and the belongings in the vehicles versus a citizen that mistakenly got into a car that looked like theirs in a grocery store parking lot. We're tasked with making these decisions every single day, and the state's attorney's office acts as another review in this. And I can't recall a time in my 14, 15-year career here at the Brat PD where anybody has been charged or prosecuted because they made a mistake and entered somebody else's vehicle. Officers are very intelligent and well tasked at differentiating between that. What I can say is we need more tools. We need more tools to hold people accountable and show that this activity won't be tolerated in our state and municipalities. I believe that the new language in the unlawful trespass and OOC statutes provides us with some of those invaluable tools. Thank you.
I just want to make clear that Senator Wahowski has a comment or question. When I bring up my own personal case of misidentifying a vehicle, part of our job here is to not have unintended consequences of the bills we pass. And there are examples throughout the nation where there have been unintended consequences to legislation passed, particularly in the judicial area. For example, New York passed laws about strict law with mandatory minimums if somebody was driving a vehicle intoxicated and that was loaned to them, or something like that. Ended up, the first case ever brought was two brothers where the 20-year-old or 21-year-old had allowed the 18-year-old to drive and was trying to avoid driving while drunk, but ended up in an accident. And so they were charged with a mandatory minimum, and, you know, lawmakers throughout New York. So this is not what we intended, but it's what they did. So part of our job is to make sure that unintended things don't happen. But Senator Bowles.
Yeah, I appreciate that. And I think it's also important as we think about unintended consequences that we think about the implicit bias that is rife through our criminal legal system and our whole society. But the story that you shared, I'm a little confused how that person should have known the car was stolen, given that the car wasn't stolen. The mother gave it to the son to use. So in that instance, it wasn't a stolen car. So I'm really confused why there is a sense that that should have been treated as a stolen car.
Yeah, I mean, I could have provided more context that the mother, that was a situation where the mother gave it to the son, but then requested it back. And the son said, well, I gave it to this person. I can't get it back to you at this point. So she wanted to report it as a stolen vehicle at that point. She let him borrow it. She was no longer giving him permission to borrow it and wanted it returned to her.
In the drug world, I know it's very common to rent vehicles as well, and then use those vehicles across state lines. Are you seeing a lot of somebody loaning a vehicle for drug purposes in Brattleboro?
Yes, I would say that happens. That would happen. And a lot of the times rental vehicles are used in that process.
Okay, any other questions for Lieutenant? Lieutenant, thank you so much for joining us today. We really appreciate it. We appreciate your testimony. Your testimony is that sections 2 and 3 are really important to law enforcement.
Yes, sir. I think it would be a great help in, again, holding people accountable and getting them into, whether it's diversion, has been spoke about, whether it's diversion, whether it's the court process or corrections, or even getting them into treatment. I think it's a step in the right direction to stop people from offending the community.
Thank you. All right. Our next witness is Stephen Brown, who's Deputy State's Attorney in Windham County. Windham County loaded today. Senator Sheen, did you have anything to do with this?
It's weird how that happens. I don't know.
You know Senator Hakeem, I'm sure.
See,
I do. Good morning.
And I'll let the rest of the committee introduce themselves.
I'm Senator Phil Baruth from Chittenden Central District.
Senator Bob Norris, Franklin County, and the town of Elbert and Glendale County.
Senator Tanya Vihovsky, also Chittenden Central District.
And I'm Dick Sears, from Bennington County, representing the district, which includes Wilmington, which is part of your district. So.
It is, Senator. I'm actually a Wilmington. I grew up in Wilmington, so
Oh.
I know your one town in Windham County very well. My name is Steve Brown, and I am a deputy state's attorney in Windham County. I've been a licensed attorney since 2006. I've been with the state's attorney's office since 2007. Before joining the state's attorney's office, I worked at a general practice law firm where I primarily practiced in criminal court as a defense attorney. Since I've become a prosecutor over the last 16 plus years, I have prosecuted everything from disorderly conduct to aggravated murder. And I'm testifying today in support of H 563. I can tell the committee that I understand, speaking with Tim, that all 14 elected state's attorneys support H63 as drafted. I don't have prepared remarks, but I do, if it's okay with the committee, I would like to address a couple of the questions that have come up, if that'd be helpful.
Yeah.
So Senator Baruth and Senator Sears gave, I think, the classic example of the unintended consequence of this type of law, which is we're worried about prosecuting people who get into the wrong car. I also drive a car that is quite common. It's a Honda Accord, and I myself have attempted to get into the wrong car. But what I think is highlighted by Chief Burke and Lieutenant Petlock is that we have to look at the circumstances around those events. And in each one of those events, Senator Sears' example, in my example, Senator Baruth's example, we had somebody who had a car in the parking lot with the keys that match a car. And I think any reasonable law enforcement officer and any reasonable prosecutor would quickly disregard any concerns that there was any criminal intent based on those circumstances. And we look at the circumstances in every single day, every time I charge a case, I am looking at the facts and circumstances around the case and electing whether to use our discretion to charge somebody with a crime. And I think we have to place some trust in our law enforcement officers to make that call on the street. And if they make the wrong call, we have prosecutors who are highly trained who hopefully will make the right call. And then there are other steps along in the process as well. But we have to keep in mind that there are many checks and balances. And like any crime, the facts and the circumstances around the event need to be taken into consideration. There was a question about continued. Yes, sir.
Hey, let me just say one of the reasons I'm so sensitive about this today is that what I've seen, particularly with social media, Bennington has the Bennington scanner page, which anytime a police officer stops someone, we hear about it. And, the name goes out over the scanner page. So Joe Jones was pulled over and nothing happened, but we still know Joe was pulled over. And so must be something wrong with Joe that he got pulled over by a police officer. Well, maybe he had a broken taillight. I don't know. And so I can just imagine Dick Sears caught in the wrong car, no matter what it was, that's on the scanner. Now it's public knowledge. It's all over Facebook. It's all over social media. And, state senator, chair, Judiciary Committee breaking into cars. That's the story that comes out. And it doesn't matter if the police officer just decided that, Dick was telling the truth. He got into the wrong car. It's already there because, we have a scanner and, police have to call in when they check. I mean, I had a person in my driveway, Christmas, I think it was Christmas Eve, and somehow the police officer wanted to make sure the car was okay, and so they, you know, as she pulled out of my driveway with my granddaughter, they called in the number. Well, it ended up on the scanner page. There was nothing wrong. The car was fully registered, but they know now the name of the person who was driving the vehicle and owned the vehicle. You know, and it's just today's world is so much different than it was before then. So that's one of my concerns. I want to make that clear that, you know, no matter how, and I do trust law enforcement, I do trust the state attorneys to make the right calls, but the information is already out there.
So, Senator, I have to say that this concern that you raise is valid, but it exists across the board on every police contact, and I think you cited a couple of examples in your statements, but this is not unique to H563. This is a problem that is endemic with our use of media and scanners. You know, I don't think that this is something that is going to be. I don't think H63 is going to inflame those concerns any more than they already exist. There was a question. There was a question about the continued use language in the motor vehicle. I think Lieutenant Petlock's example does touch on that. Continued use, I think, was intended to cover the situation where I lend my car to somebody and that person has my authorization to drive the car, and then I revoke it after, let's say, a week. I say, I'd like my car back. And that person refuses to return the car. I think the continued use language would cover that example where consent is revoked for the use of the car. I'm not sure if that makes sense. Yes, Senator.
Senator.
It does, and I'm just wondering if we could add a couple of words, saying or continues to use after permission is revoked. Would make it clearer in a first reading what's meant there.
So the continued use language has been in the operating without owner's consent statute for as long as I've been a prosecutor, I think. I don't recall a time where it wasn't there. We don't, I was looking at the model instructions just a few minutes ago, trying to come up with the best answer I could provide you, Senator. And I am not an expert in statutory construction, so I will leave that to the experts who construct the language in our statutes. I haven't seen any problems with that current language that's been there for years. So I'm not sure if there is a problem that needs to be fixed, but I would leave that to the experts who draft these statutes, which is that's not my expertise. Another question that came up was the grand larceny of a motor vehicle, and I would echo the statements that Chief Burke made about the inclusion of the grand larceny of a car or the stealing of a car. I think that the other aspects of H63 are way more valuable for us in law enforcement than the inclusion of the Section 1 concern that Senator Sears raised. You know, we have anytime somebody steals a car, we have the option of charging a grand larceny if the value of the car is over $900. And if they attempted to steal the car, we have attempted grand larceny still. So, you know, I don't know how valuable that part of H563 is for us as prosecutors and law enforcement officers. But I would certainly say that the other aspects of H563 are very valuable and provide a another tool for us to address a collection of criminal conduct that is currently very hard to pigeonhole into a statute. The other concern that was raised at the very beginning was the know or should know standard, and that's not a standard that is brand new to criminal law. There are a number of statutes on the books in Vermont that use know or should know. I could cite two examples. One is the sexual abuse of a vulnerable adult under 13 VSA 1379. And another example is the definition of stalk in Title 13. Both those statutes use knows and should know or should know. The mens rea of knows or should knows or should know, I think really strikes a balance between not intentional or knowing conduct versus making it strict liability or reckless. I think it's just a step below knowing, and I think it is it's not going to open the floodgates to us charging hundreds of people with crimes. It's going to address certain people who are engaged in this conduct on a regular basis. It'll allow law enforcement to intervene and to hopefully divert the person into a restorative justice program, or if it's a person who's already involved in the criminal justice system, it'll allow us to address the conduct with the other tools that we have.
Can I ask a question about that? I'm looking at in that section on line 10 of page 3, it is knows or should know. But on line 17 of page 4, it's the operation without the owner's consent, should have known that the person did not have consent of the owner. Shouldn't we do the same standard in both?
So
I guess out of consistency, I'm wondering why we do two different things. One is knows or should have known, the other one is should have known. I think it'd be easier to have should have known in both, or the same standard in both.
So as I previously indicated, I'm not an expert in statutory construction, but I think what you're pointing out is valid and probably does make sense.
Okay. So another one. Senator Sheen.
Thank you. Thank you, Steve, for testifying. I was wondering if you could go a bit deeper into what sort of facts you look at when it comes to the should have known standard, and could you just go a bit more into it?
Sure. So let me cite two examples. One actually occurred in Putney just a couple of months ago. I received a call in the middle of the night from the Vermont State Police who got called to a residence for an individual that was caught by the homeowner going through the car. So when you look at the facts and circumstances in that case, this person had no connection to the neighborhood. They had no connection to the homeowner. They had no reason to be in the car. They didn't have another Honda Accord parked next door where they were confused about the car they're getting into. They clearly were entering somebody's car, and they should have known that they were not permitted to get into that car. This is not a case where somebody was at Hannaford's. They walked out of the store and they got into the wrong Honda Accord. It was very clear that the person had some criminal intent to be in that car. Another example in the operating owner's consent world, you would look at does the person driving the car have any connection to the person who owns the car, and can they explain in any sort of credible way why they're driving the car and how they got permission to drive the car. And so you look at the statements, you look at the circumstances around the operation of the car, where they're driving the car. If the car's from Chittenden County and the car's down here in Brattleboro, and the person has no reason to be driving it and doesn't even know that the car came from Burlington, that would raise some significant questions in our minds, and I think it would support an inference from a jury or other fact finder that the person should have known or did know that the car was stolen. Does that answer your question, Senator?
It does, thank you.
Senator Bahowski.
Yeah, I'm still just trying to kind of wrap my head around how the sort of inferences there get made. So one of the things you said is the person driving the car has no idea the car came from Chittenden County. How would that infer that they should have known the car was stolen? It makes more sense to me that if they knew the car was coming from Chittenden County, that would make more sense that they should have known it was stolen.
So I think you got to look at all the facts, and my example maybe wasn't well developed, but the fact they knew the car came from Chittenden County may, in certain circumstances, highlight that they knew the car was stolen, or it may highlight the car wasn't stolen. But I think looking at that fact by itself does nothing. You need to look at the other facts of what the person was doing with the car, how long they had the car, who they said they got the car from. I mean, there are a lot of circumstances that you need to examine before you could jump to the conclusion that they should be arrested or they should be charged with a crime.
Okay. Okay, thanks.
Thank you.
Senator Norris has a.
Yeah, Senator Norris.
Yeah, Steve, thank you for being here. So is it my understanding that under H 563, that whether it's the known or should have known standard along with the intent, that the state has the burden to prove beyond a reasonable doubt both of those particular incidents that I just mentioned?
Yeah, the state always has the burden of proof to prove beyond a reasonable doubt. And currently we have to prove knowing. If the legislature passes H 63, we'd have to prove that they, beyond a reasonable doubt, that they knew or should know. We still have a proof. We always have a proof issue, and we still need to be able to prove beyond a reasonable doubt to 12 jurors that the person committed a crime.
Thank you.
Okay. Any other questions? Thank you so much for joining us. We appreciate it. Nice to meet you.
Thank you. Take care.
Okay, we're gonna take a 15-minute break until, I think it'll be 1:05 after, and 10, and then we'll get back to H 534. And after our